We're going to start with the Equal Employment Opportunity Commission, which is the agency that regulates equal rights in employment, race, sex, age, disability, religion, national origin, and what have you. And the logical question to start with is, well, what is on the EEOC's radar? And we need to realize that really all of these agencies are agencies of limited resources. They're funded with our tax dollars. They have very limited budgets with which to work. And where the EEOC has decided to put the bulk of its resources is what it calls systemic discrimination. The EEOC has decided, look, people are going to come to us with charges of discrimination. An individual says they're aggrieved, so-and-so is fired from their job. That's not really, that's not the best bang for our regulatory buck. The best bang for our regulatory buck is going to be where we can, put dollars towards those acts of discrimination that don't just impact an individual, but impact many individuals within an organization. A policy that impacts numerous people across the board. And this type of kind of systemic company-wide discrimination takes on lots of forms, and it's not always intentional. And where the EEOC has made really its biggest mark in the last 5 or 6 years has been in what it calls kind of unintentional discrimination. Neutral policies that impact, that disparately impact one group, one protected group more than a non-protected group. So, for example, you have the instance of credit checks. Lots of employers run credit checks on employees. Before they hire those employees, they say, we want to find out how you manage your money. We think maybe for a particular position it's important how you are responsible with your money. Maybe you're going to be handling our money, and we want to make sure that you're not bankrupt, that you are responsible in how you handle your money, that you and some just think it just bears on someone's character in general and run these credit checks across the board. The EEOC has said that we believe that the use of credit in employment, for example, without a good reason, and we're going to talk about what that means in a minute, has the potential to disparately impact certain minority and ethnic groups more than others. And so the EEOC says if we look at the raw numbers, we know that, for example, African Americans and Hispanics across the board, for whatever reason, have worse credit ratings than Caucasians do. And so for an employer to use credit as a raw baseline criteria for making a hiring decision has the ability to disparately impact African Americans and Hispanics at a greater rate than Caucasians. And so we, as employers, cannot, as a baseline, use credit without a reason for a hiring decision. And we saw locally, the EEOC right here in Cleveland brought a lawsuit against Kaplan Higher Learning, the educational company. Really interesting lawsuit, not so much from the allegation, which was that they were using credit to screen on applicants, but from how the EEOC, and this is kind of a little bit of insight into how the agency is running currently, and how the EEOC went about trying to prove their case. What the EEOC did to try to prove their case was say, we are going to try to collect as much data as we can on individuals that Kaplan hires and don't hire. How are we going to do that? We are going to get the list of all the names of all the people that Kaplan either hired or didn't hire that they ran these credit checks on, and then we're going to go hire an expert witness who's going to pull DMV driving records on these individuals because Kaplan wasn't tracking the race of the individuals that it was hiring. And so how are we going to figure out whether someone's name on a list on whom a credit check was run is white, black, Hispanic, or otherwise? And so they pulled all these DMV records and then hired an expert to do what they called race rating. So the EEOC pulled up these DMV records that had the lovely photographs that you get taken every 4 years when you get a new driver's license, and this race rating expert looked at the photograph of each individual to say this person is Caucasian, this person is African American, this person is Hispanic, this person is Asian, or this person is otherwise, and this person who said they were an expert in figuring out what race someone is by how they appear, what they look like in a photograph, this expert then put a race to a name and then did a statistical analysis to figure out what impact this, this use of credit in hiring had. And if you step back and think, for an agency that is charged with eliminating discrimination in the workplace based on the use of stereotypes, to base their entire litigation strategy in a case on the stereotype of what someone looks like in a photograph. We think this person looks white, we think this person looks black, we think this person looks Hispanic, to me is, and I hope to all of you, is fairly offensive. You have the EEOC who says we believe that employers should not stereotype in making hiring decisions, and yet they base their entire litigation strategy on those very same stereotypes. And thankfully, the federal court here in Cleveland and the Sixth Circuit, the federal appeals court down in Cincinnati, agreed, and that case was dismissed based on this, what the court said was really sham science in this race rating. But again, a little bit of insight into not just what the EEOC is regulating in this area, but how the EEOC is choosing to go about litigating. And it carries over into the criminal background area too. Just like the EEOC says criminal or credit histories have a disparate impact based on race, so do criminal histories, criminal backgrounds. And numbers, I mean, the numbers do back it up. African Americans and Hispanics are incarcerated at a rate something like 3 to 4 times as Caucasians are incarcerated. And so if you just look at the raw numbers, these policies do have a disparate impact based on race. But the EEOC has taken the position that because of this disparate impact, it is unlawful for an employer to disqualify someone from employment solely based on a criminal history. If you cannot have a policy that says, if you are a convicted felon, we will not hire you. That's what the 2 examples on the slide, the BMW case and the Dollar General case, that's exactly what was alleged in that case. Just this past week, the EEOC announced that it reached a $1.6 million settlement with BMW after the court denied BMW's attempts to have the case thrown out. BMW agreed to pay a $1.6 million settlement to the EEOC for a group of 70 or 90 individuals that were denied employment solely because they had a criminal history. And again, just as I think the EEOC is being a bit intellectually dishonest with their use of these race raters in these credit cases, I think the EEOC is also being intellectually dishonest in how they're handling criminal histories, because one of the things that both BMW and Dollar General did in their cases was say to the EEOC in discovery, okay, EEOC, you tell us how you hire. What are your hiring standards? Show us your hiring criteria. Show us your criminal background check policy. And what came out in those cases was, even though the EEOC takes the position that an employer can't have a blanket policy that says, thou shalt not hire if you are a convicted felon, that's exactly what the EEOC's own internal policy says. The EEOC's own hiring policy says, if you're a convicted felon, you can't work at the EEOC, period. All right, EEOC's own policy, but that's not what the EEOC says. That's not what the EEOC says you should be doing when you hire someone. Instead, the EEOC says we presume that because felonies disparately impact minorities, we presume there's this disparate impact, and employers, you need to show us that you have a good business reason for using a felony as a hiring criteria anyway. And so what the EEOC says you have to do is, number one, set up a targeted screen. So you have to pre-screen every applicant for a felony to figure out whether or not that felony does or does not, based on the individual and the job in question, disqualify that person from employment as a baseline. And then for those individuals that you still, once you look at the nature of the felony and the job you're hiring for, applicant by applicant, job by job, you then need to go one step further and engage in what the EEOC says is this individualized assessment and apply a variety of factors. The facts and circumstances of the offense, how many times the person's been convicted, how old the conviction is, whether there's been any post-conviction incidents, the person's work history, etc. And for each individual that you want to deny employment for because of a felony record, you need to, on an individual by individual basis, go through these factors. And this is regardless, for example, the EEOC also says, of whether or not there is a state law that requires you not to hire someone. So if you operate a school, for example, there's an Ohio state law that says certain individuals who have certain felony convictions can't work in a school, period. The EEOC says, we're the federal government, we trump state law, and therefore we say, state law be damned, we don't care. You still need to go through this individualized assessment, job by job, individual by individual, regardless of what state law says. And I can tell you, I don't care what the individualized assessment says. I certainly don't want my kids going to a school where they're going to even consider hiring a convicted sex offender, a convicted drug offender. I don't want convicted sex offenders coming to my door to deliver pizza or Chinese food. Regardless, the EEOC says, we don't care. You need to go through this individualized assessment, person by person. It doesn't make a difference. And the EEOC is out there enforcing this, filing lawsuits, $1.6 million against BMW. Two other issues I want to touch on with the EEOC, where the EEOC has gotten very active in regulating what employers are doing. LGBT discrimination and pregnancy discrimination. Title VII, the federal law that prohibits discrimination in employment, does not include sexual orientation, gender identity as a protected class. The EEOC, however, has recently taken the position that regardless of what Title VII says, we believe that sexual orientation, gender identity, really is the same thing as sex. It's how someone identifies as the gender with which someone identifies. It's the partner with which someone chooses to have relationships. We view that the same as sex, and for that reason, we, EEOC, really don't care what the law, Title VII, says. We are, regardless, going to interpret sex under Title VII to include sexual orientation and to include gender identity. And the EEOC is currently, as a regulatory position, accepting charges of discrimination on the basis of sexual orientation and gender identity under the category of sex. Just this last year alone, the EEOC accepted over 1,000 discrimination charges filed by individuals alleging either sexual orientation discrimination or gender identity discrimination under this large umbrella of sex discrimination. They are actively pursuing that issue both administratively and in litigation that it has filed in courts around the country. The EEOC has said we're not waiting for Congress to act to amend Title VII to include these as protected categories. We're not waiting. Right now there's 18 states that include, in their own state discrimination laws, include these categories as protected classes. But we're not waiting for the other 32 states to catch up either. We're just going to start accepting these charges and litigating this position as if the law says sexual orientation, gender identity are included as sex discrimination. So from a how do we bring our policies compliant standpoint, you should be thinking about, even though Title VII still does not include sexual orientation, gender identity as protected classes, you should be thinking about including them in your EEO anti-harassment policies as protected categories that you will, against which you will not discriminate in your businesses. And it's not just the EEOC that's taken this position. The Department of Labor has recently, in a policy statement, said employers that are covered by the FMLA need to, and this was even before the Supreme Court same-sex marriage decision said that employers need to treat same-sex spouses as spouses under the FMLA. And so if you have, currently if you have same-sex spouses or employees in your workplace that are engaged in same-sex marriages, that are married to a spouse of the same sex, you need to treat that person as protected under the FMLA when their spouse, for example, has a serious health condition for which the employee requests leave. And that's regardless of the law of the state in which we're in. So Ohio currently doesn't recognize same-sex marriages, but New York does. So if you are an FMLA-covered entity, you have an employee that goes to New York and gets legally married to someone of the same sex. As an Ohio employer, you have to treat that spouse, you have to treat that employee, recognize that employee's marriage under the Family Medical Leave Act. The last topic I want to touch on in the EEO area deals with pregnancy discrimination. There's a big debate going on right now in this country about leave rights, how much leave someone has to have, whether or not that leave should be paid or not. One area where this comes up often is in the area of pregnancy discrimination. Title VII, which protects pregnancy as sex discrimination, does not say in the statute that we have to accommodate people's pregnancies, make accommodations for employees that are pregnant. What the law says is you have to treat pregnancy the same as any other disabling condition, no worse than. And so what the EEOC has done is come out with policy statements that say things like, because the law says you have to treat pregnancy the same as other similarly disabling conditions, even though Title VII does not say you have to provide accommodations for pregnancy. If you make accommodations for any other reasons, you can't treat pregnant workers worse, and so therefore you have to accommodate employees' pregnancies. If employees, for example, pregnant workers need time off from work, unpaid time off from work because of their pregnancy, you have to grant it. If employees who are pregnant bring in a doctor's note that says this employee can't lift more than 25 pounds, if you've made similar accommodations to employees with back injuries, for example, you have to, as a matter of course, make the same accommodation for a pregnant worker. The EEOC has really written a reasonable accommodation standard into Title VII for pregnant workers on this theory that you can't treat pregnant workers any worse than anybody else. And the ADA, the Americans with Disabilities Act, requires you to make accommodations to disabled workers, and therefore, because of that, the EEOC has essentially bootstrapped an accommodation standard onto the pregnancy for pregnant workers on the theory that because you can't treat them any worse, because you have to accommodate disabilities, even though pregnancy is not a disability, you can't treat it worse, and therefore you have to treat it the same. Nowhere do we find that in the law, and yet it is a policy statement that the EEOC has actively pursued, both in its written policy statements and in litigation.